Hello again. In this video, I am going to talk about the important constitutional principle of the legislative supremacy of Parliament. This principle is also known as the sovereignty of Parliament, and I am going to use the two terms interchangeably. But it is important to remember that it is only when it is acting in a legislative capacity that Parliament is sovereign. Like the rule of law, the starting point for the modern understanding of the principle of sovereignty of Parliament comes from Dicey. In Chapter 1 of the Law of the Constitution, he says, "The principle of parliamentary sovereignty means neither more nor less than this, namely that Parliament has under the English Constitution the right to make or unmake any law whatsoever, and further that no person or body is recognised by the law of England as having the right to override or set aside the legislation of Parliament." So in Dicey's understanding, Parliament can enact any legislation that it thinks fit, and no body, no court, nor any superior legislature can overrule the judgment of Parliament. And we can see this principle in operation in the UK Internal Market Bill, which had just completed its passage of the House of Commons when I filmed this, and which I discussed in the video on the rule of law. To recap, the government wants Parliament to pass legislation which will authorise the UK government to make rules that breach the EU withdrawal agreement, in particular the Irish Protocol contained within the withdrawal agreement. And why shouldn't they? I suggested in the video on the rule of law that just because legislation offended against the core principle of the rule of law didn't mean that the statute wasn't validly enacted law. Although I did suggest that the courts might need a very clear signal in the wording of the statute if they were expected to interpret the legislation as an intent to violate the principle. But if that intent is made clear, the principle of legislative supremacy of Parliament means that the courts must give effect to it. After all, the principle means that Parliament can make any law whatever, and no body has the power to override or set aside that law. And there is a long line of authority that Parliament can legislate in contravention of international law, and that the courts must give effect to that legislation, notwithstanding that it might oblige or permit certain persons or bodies to act contrary to international law. I will mention just one case, and I hope it will appeal to my Canadian students, because it is a Privy Council appeal from Canada. By the Privy Council, we mean in this context the law lords sitting as a final court of empire or dominion. Canada abolished the appeal to the Privy Council in 1949, but this case dates from 1932. The case is Croft and Dunphy, and it is concerned with a ship, the schooner Dorothy M. Smart, which had sailed from the French Caribbean with a cargo of rum and other dutiable liquors. The vessel was boarded 11.5 miles off the coast of Nova Scotia by Canadian customs officers, and the vessel and its cargo were seized. Canadian law, the Customs Act of Canada as amended to be exact, said that the seizure could happen of a Canadian registered vessel anywhere up to 12 miles out to sea. But Dunphy, the ship's owner, tried to argue that the seizure was unlawful because, as a matter of international law, it took place out of Canada's territorial waters. This was a disputed issue of international law at the time. But the question was not one to which their lordships considered it necessary to give a determinative answer. To what distance seaward the territory of a state is to be taken as extending is a question of international law, upon which their lordships do not deem it necessary or proper to pronounce, is how the judgment puts it. All that mattered was that the Canadian statute said 12 miles, and that was all the courts had to have regard to in deciding the matter. I should say that there was a matter that was relevant to the decision, and that was whether the Canadian Parliament, which was a creature of a British statute, the British North America Act 1867, had the same authority as our Westminster Parliament. You may remember the British North America Act because it is now cited as the Constitution Act 1867, which was part of your materials for the first seminar. On the question of the compatibility of the Canadian law with the British North America Act, the Privy Council said, "Legislation of the Imperial Parliament, even in contravention of generally acknowledged principles of international law, is binding upon and must be enforced by the courts of this country." The only question was whether Parliament of the United Kingdom, the Imperial Parliament in the language used by the Privy Council, had also conferred on the Dominion Parliament the power that it enjoyed to legislate contrary to international law. But that was a matter of interpretation of the British North America Act, not one of international law. And as a matter of interpretation of that Act, the Canadian Parliament did enjoy this competence. So, following the principle of legislative supremacy, Parliament can validly enact even legislation that flatly defies international law. It may be imprudent to do so. It may even give rise to the liability of the United Kingdom in international law. But as a matter of the law of the land, that is not an obstacle to Parliament enacting such legislation and the courts following it. As an aside, our approach to international law in the UK is sometimes described as dualist because it is based on the idea that international and domestic law exist in two separate spheres. International law can only impose rights and obligations on individuals once it has been transposed into domestic law, as the Geneva Convention has been by the Geneva Convention Act 1957. This is very much a consequence of the principle of legislative supremacy, because if we took the opposite approach, called a monist approach, it would make international law supreme over domestic law and over Parliament. It would also give the executive greater power than our Constitution in fact gives us, because the treaty-making power is part of the royal prerogative in our Constitution, exercised by Her Majesty on the advice of ministers. So to return to the Internal Market Bill, we can say that the principle of legislative supremacy means that there is no bar to Parliament enacting legislation that breaches the EU withdrawal agreement. And equally, there is no bar to Parliament enacting legislation that authorises other constitutional actors, in this case ministers or the executive to put it in the abstract, from violating this or any other international obligation. You might ask, does this mean that the principle of legislative supremacy means that the Internal Market Bill is therefore constitutionally unproblematic? Well, no, it just means that only Parliament itself has the power to correct the problem. Just because the courts will give effect to the enactments of Parliament doesn't mean that the bill is unproblematic at all, in fact. In the Rule of Law mini lecture, I noted that Dicey used as a synonym for the rule of law the phrase the predominance of legal spirit that he saw as a characteristic feature of English law. And just as legislation, even legally valid legislation, can undermine that predominance of legal spirit, we could also say that in passing the Internal Market Bill, Parliament may be undermining its own supremacy. This is because of the extremely wide legislative power conferred on ministers to make regulations in the Internal Market Bill, even to the extent of making laws that are contrary to the instructions of Parliament. Isn't there a risk here that Parliament is giving away its own sovereignty? Of course, by the doctrine of legislative supremacy, it has the authority to do so. But beyond a certain point, such broad delegation goes against the spirit of the sovereignty of Parliament, just as it runs contrary to the spirit of the rule of law if the jurisdiction of the court is limited. And the courts may well take notice of this and think creatively about the limits which Parliament has placed on ministerial rulemaking and which it hasn't. Were this to happen, you could say that it would be an example of judicial adventurism, or lefty lawyers or activist judges stepping beyond their proper role. Alternatively, you might argue that this is the separation of the roles of law-making and law enforcement in the separation of powers in action, or at least the partial separation that we have in this country. There are no easy answers to questions about how far the judges can go to render a reading of legislation that is compatible, not just with the constitutional allocation of powers, but with the spirit of the principles of the Constitution. And if you have watched the video on the unstructured Constitution, you will be aware of my view that one of the distinctive features of our Constitution is the large degree to which the particular interpretation given to constitutional principles is the product of the different justificatory narratives of different constitutional actors, with no obvious mechanism by which these can be reconciled or given authoritative reconsideration. Nonetheless, I hope you're beginning to see how the different constitutional principles fit together, as I say in the rule of law video, if not exactly harmoniously, then at least in a way in which one of them can never completely displace the others. And I'll see you in a future video.